Good afternoon, and welcome to our webinar today. I'm James Vann with Vann Attorneys, and we're going to be talking about bankruptcy today, what happens when your customer files for bankruptcy. And we hope that you will enjoy this webinar that we're going to do. For those of you who dial in on a regular basis, you know the drill. If you have a question, please let us know. We would love to hear from you. You may submit questions to us either on the GoToWebinar control panel, which is on your screen, and you can submit a question that way, or you may email us at webinar@vanattorneys.com. So either way will work. So we're going to go ahead and get started today and talk about what happens when your customer files for bankruptcy. What does that do to your AR, and how should you handle it? So we're going to be talking about that issue, but also in conjunction with that, the automatic stay, which many of you know what that is. It's when your customer files for bankruptcy, we as creditors are stayed and stopped from taking certain actions to collect the debt. We'll talk about that. How do you prepare your claim, and what do you do if you have a preference claim down the road? So the automatic stay is a bankruptcy code provision that says, with some exceptions, that creditors cannot take certain actions against your customer if you're still owed money. For example, you cannot proceed forward trying to get them to pay you. You really should not call them. Actually, you should not call them. You should not write them. Even people say stop sending invoices at that time, stop sending statements. Anything that you're trying to do in an attempt to collect money should be stopped. The purpose of the automatic stay is to sort of preserve the status quo of the bankruptcy case at that time and to stop anybody from pursuing against the debtor. And once the debtor has filed bankruptcy, there are actions that creditors can take within the bankruptcy court, but you really are not supposed to do anything outside the bankruptcy. And obviously, as representing creditors, we want to make sure you get paid as quick as possible. But think about it this way: if you are a creditor and there's another creditor out there who does something or takes some action and they get paid in full, or they get a big payment after they file bankruptcy, and you go, wait a minute, that's not right. The debtor shouldn't pay them and not pay me. You're exactly right. So the idea is to try to make sure that the creditors are treated equally or fairly in the bankruptcy court. That's sort of the idea. But that's in general what the theory is. The automatic stay is not applicable to other parties other than the company or individual who filed bankruptcy. For example, guarantors may or may not be included in the bankruptcy stay, or general partners. So, for example, let's say you're one of your customers files corporate bankruptcy, but you have a personal guarantee, and the personal guarantee did not file for bankruptcy. Under a lot of circumstances, you can continue against the personal guarantor for the recovery of whatever the customer owes you. There are some cases where if you pursue the personal guarantor, that personal guarantor is so important to the company that filed bankruptcy that the bankruptcy court would say, you got to stop what you're doing as well. It's called a co-debtor stay. But not all guarantors or not all other parties would be in a circumstance where if you pursued them to collect the money, that it would hamper or harm the bankruptcy estate. It's really on a case-by-case basis. What you'll also see sometimes is they'll say that such and such company has filed for bankruptcy, and they'll also include the individual owner's names in it. What they're trying to do is create an issue where you cannot go against the personal guarantors as well. So again, every case is a little bit different, but hopefully that helps you with that a little bit. We talked about it does not apply to co-defendants. Will be allowed to proceed forward if you've got a case pending in state court or federal court. It's applicable to all the cases in bankruptcy court and applies to all creditors and third-party actions that might affect or impact the bankrupt bankruptcy estate. So, for example, the automatic stay, all forms of secured creditor actions are stayed. For example, anything in the court system would be stayed. If you've already sued your customer to try to recover funds that are owed, the case in state court would stop pending the bankruptcy court. So just understand that a little bit. Same thing if you're trying to foreclose, pick up assets, anything like that, all that stops while the bankruptcy court's going on. You can ask for permission from the bankruptcy court to set it aside, but that is to set aside the automatic stay, but initially that stops. The stay also includes most forms of any kind of litigation or appeals and arbitration. So that hopefully that makes sense to you. Again, as I said, the automatic stay you should not send demand letters for payment. You should stop telephone calls. Any attempts to collect money from the debtor that filed bankruptcy should stop. If you are a creditor and you're considering some type of action against the customer to recover funds that are owed, it's really best to seek whoever you go to for legal advice to think about the bankruptcy code and cases, because every bankruptcy court is a little bit different. Every case is a little bit different. Depending on where your customer files for bankruptcy, every bankruptcy division could look at the case a little bit differently. Well, what happens if you do violate the automatic stay? The bankruptcy code addresses that, and the violations of the automatic stay are considered to be void. That is, whatever action you take, if you recover something that's void, that can be turned around and undone, and also can create consequences for the creditor. Some of those can be financial consequences. Some courts have held that actions taken in violation of the stay are voidable rather than void, and that is that they could be set aside. One could be set aside, the other are automatically set aside. Also, if the trustee is involved in it or the bankruptcy attorney, they notify the court of action that's being taken. A creditor could be held liable for attorney's fees, any costs or damages that the debtor incurred because of the violation of the automatic stay. We recently had a client who got notice of a bankruptcy court proceeding. They took certain actions that's in violation of the bankruptcy code, and then the bankruptcy trustee filed a motion for sanctions, which is a motion for penalties against our client. And then thankfully they said, we need to get somebody else's help on this thing. So they finally got some legal help on it. Because there are ways to approach those circumstances when it happens. Sometimes it's accidental. Sometimes it's, you didn't even, one hand didn't know that the other hand knew that there had been a bankruptcy filing. And then other times it's just plowing ahead and not really considering whether or not there is a bankruptcy, or even when you know that there's a bankruptcy proceeding, continue to do what you're going to do. Those are where the bankruptcy courts really get upset, is when the creditors are taking actions to try to grab assets or grab funds that are owed to them in disregard to the bankruptcy court. The main thing is this: any judge really expects people to follow through on their orders, and the bankruptcy court judges typically interpret a automatic stay order to mean you really should stop pursuing the debtor. So if you ever find yourself in that, make sure you seek out legal advice, because it can save you a lot of time and trouble, and hopefully money as well. So you can obviously have some forgiveness in the bankruptcy court, depending upon how that comes about. So you want to make sure that you don't set yourself up for penalties for the bankruptcy court as well. So what about claim preparation? We've helped a number of clients over the years, probably close to thousands, in bankruptcy court as a creditor. And there are those who literally throw their hands up and say, I don't want to deal with this. And we certainly understand that. And then there are those who love getting into the weeds of the details of the documents. The better you can make your claim and prepare it, depending on how large it is, And if it's one or two invoices, not that big of a deal. If it's hundreds of invoices, then the more information you can pull together when they file for bankruptcy, the better off you're going to be. Because there are a lot of claims and a lot of aspects of the bankruptcy code that you, depending upon how old the debt is when your customer files for bankruptcy, you really can do things that can help you as a creditor in the bankruptcy court. One comes to mind, I won't call them by name, but this person loves Excel spreadsheets. And honestly, I'm horrible at them. But this client they got hit with a huge preference claim. We're going to talk about it and just what preference claims are and how do you help with that. But this client took all of their invoices, all of the dates of payment, and put this in a spreadsheet. And it was an amazing spreadsheet that showed that, in fact, the payments that they had received prior to the customer filing bankruptcy were not, in fact, preference claims. And the way that person put it together was, I mean, y'all, I'm telling you, when I say it was a huge claim, it was huge. And the time that person spent putting all that together probably saved them a couple $100,000. I mean, it was that huge. So the reason I say that is the more information you can get, the earlier you get it, the better off you're going to be. So I would encourage you, when you know a customer's filed for bankruptcy, take a little bit of time, set it aside, gather all your documents pertaining to that account, look at it, look at the invoices, delivery tickets. Is it right? Is it accurate? If you have a payment bond claim, or if you have a lien claim that attaches to that, or any kind of a claim that you can make to another party, make sure that the I's are dotted and the T's are crossed, because that's a great time to do that versus later on when you're trying to scramble and get it covered. And then prepare to submit a claim to the bankruptcy court. If you've already filed a claim of lien, if you have lien rights, then that's great. If not, make sure you get your documents prepared so you can go ahead and get it filed. And the same thing with a payment bond claim, making sure that all your delivery address, the dates, you have that all in hand so that you understand what your rights are. Sometimes you may have a reclamation right, and that is where, if it's early enough, you can go against the customer or the debtor to reclaim goods if those goods are still in their possession. So again, looking at your invoices and the delivery tickets early can make a huge difference in how your claim is handled in the bankruptcy court. Certainly on a reclamation claim, to be able to reclaim those materials from the debtor, you have to act pretty quickly. You can't wait 30, 60 days. You really need to work pretty quickly on doing that. That's when they file bankruptcy. So we've talked some about preference claims. We're going to talk about what they are, how do you handle them, and what defenses do you have to preference claims. And this comes directly out of the bankruptcy code. A trustee may avoid a transfer, which means a trustee may come to you as a creditor and say, by the way, you got paid from the from the debtor within 90 days of them filing bankruptcy. You know that, and I'll use this number, that $75,000 that you got before, within 90 days before your customer filed bankruptcy, that we are considering as a preference. We want you to pay that $75,000 back to the bankruptcy court. Not only are you out money that typically that the customer owes you, but now you got to pay $75,000 back. That never sits well with any creditors. So that's a preference claim is defined as any transfer of property of the debtor to or for the benefit of the creditor for or on account of an antecedent debt that's owed by the debtor that's made while the debtor is insolvent, and that is presumed by the law. It's made on or within 90 days before the date of the filing of the bankruptcy, and the creditor receives more than it would have in a liquidation. So those are a lot of elements of the test of what a preference is. And I try to break it down so that it's not too legalistic, but it's any transfer, any giving of property by the debtor for the creditor that's on a past due account made while the debtor is insolvent, which is 90 days before they file bankruptcy, and you receive more than you would have if they had liquidated the assets. So again, that's hopefully that helps. If you look at that definition, if you look at the definition, there are lots of ways where you can argue, well, look, this is not a preference because, and you can start picking it apart a little bit. So, again, looking at a possible preference, having knowledge by the creditor that the debtor is insolvent is not required. You don't need to know that ahead of time. Generally, the creditor has no knowledge that the debtor, that the customer is insolvent anyway. You might understand or expect the debtor is going to file bankruptcy because their payments are starting to get later maybe, or they may tell you, hey, look, we can't pay the bills anymore, we got to file bankruptcy. Each element of that definition that we just looked at a minute ago, each element of that has got to be approved by the bankruptcy court, by the trustee. So it's not one or two, but it's all of that's got to be proven. So we're going to look at each element sort of quickly so that you can sort of understand. We won't go into great detail on this because it can get pretty deep in the woods or in the weeds, and I don't want to do that on the webinar. But what is a transfer? It's any mode or direct or indirect transfer of property from the creditor to the debtor. It's very broadly written so that, for example, if for some reason the debtor is transferring something to the creditor other than cash or payment, that is defined that way. Or for example, let's say, for example, you've got a customer and they own a huge piece of real property that's free and clear, or that's almost free and clear and doesn't have any debt on it. If they were to transfer that to another creditor, generally, and not to you as a creditor, I don't know about you, but that sort of would upset me a little bit. So the definition is not a definition of payment of money. It's a transfer of any kind of asset for the debtor. Again, the property's got to be of the debtor. The word property of the debtor is not defined in the bankruptcy code. Most courts look to see if the bankruptcy estate as being all property which will become property of the estate. For example, let's say that you've got a customer that owes you money, but your customer has a customer that owes them money. Instead of that customer paying directly to your customer, they say, why don't you, as the debtor's customer, pays you directly. That sort of goes around their customer and pays you directly. For example, if you're in construction, it would be your customer, subcontractor, paying you directly, or general contractor paying you directly. Some people look at that as a preference claim. I think there's some case law out there that says, you know what, we can use that as a defense to the preference claim because it's not the money of the debtor. You could argue, but it was going to become the money of the debtor. Well, that's an argument that you'd have later. There's case law that supports that position, but that's a good defense, I think, or a decent defense. So the transfer's got to be to or for the benefit of a creditor. Creditor's got to be involved. Otherwise, the transfer may be a fraudulent transfer or a transfer for an insider. Let me go back just for a moment. I'm just thinking about this of the property of the debtor. Let's say, for example, that you've got, so let's say the debtor corporation files for bankruptcy, but right before they do that, you realize that the customer is not doing well financially. You think, you know what, I need to do everything we can because you're working on a settlement because they owe you so much money and you've cut them off, or something's brought the issue to the table where you're talking to the customer. And we've done this a lot in major settlements where we'll have the money come from, say, maybe and it's all a guess, but you think, you know what, personally they're not going to file bankruptcy because they don't have as much debt. Corporately, they may file bankruptcy because they are over their head, or vice versa. It could be one or the other. So what you could do is negotiate, okay, the payment's got to come from the personal guarantor, so that, because you think that personal guarantor is not likely to file bankruptcy. If you think that's the case, then get the payment to come from somebody else. Again, the corporation might transfer that money to the personal guarantor, and then the personal guarantor pays you. So that's one way to avoid that as being a possible preference. The fourth element is for or on an account of an antecedent debt. A credit transaction must be involved by definition. An antecedent debt is an account that's past due, and it's got to be one that's of the customer. Made while the debtor is insolvent. Again, this is presumed. It's within 90 days of the debtor filing bankruptcy. They just presumed they were insolvent before that time period. Made within 90 days prior to the filing of the bankruptcy. again, what you do is you look, when they file bankruptcy, you count back 90 days and see if you've gotten any payments during that time period. And typically it's when the check is deposited or the check clears. So sometimes it's really advantageous to, if you get a payment, and most of you wouldn't let it sit anyway. If you have a concern about the debtor filing bankruptcy, you get a check, you run to the bank, get that thing in the bank, and you pray and hope for 90 days that they don't file bankruptcy. But if you hold the check for 3 or 4 days while you're processing it internally or you're waiting on some other issue, those 3 or 4 days could wind up to snag you. So be careful. Again, made within 90 days prior to the filing of bankruptcy. When is the transfer? Typically, a transfer of real property is when it's a good against a bona fide purchase for the debtor, and that is typically when it's signed or transferred and filed. And so that's one thing you got to think about is what the dates of those transfers are. And then the last element is that the transfer you received or the payment you received before the debtor filed bankruptcy is giving you more of a payment than you would receive if the debtor company was liquidated and paid out to all of its creditors at that point. So again, sometimes you might be a preference potential, even though you got the money, but sometimes when they run the numbers, you didn't get as much as you would have in liquidation, so they don't come back to you. And so again, if y'all got questions, let us know. You can submit it 2 different ways, either on the go to webinar control panel or webinar email at vannattorneys.com. So hopefully that helps you understand what the elements of a preference is. And again, if you have a preference claim, we're going to talk about what do you do with it, and then how do you handle it. But let's look at some of the exceptions or defenses. A preference must be proven before you get to the exception. So there must be a transfer of the property, and it must be a transfer for or on account of an antecedent debt. So how do you defend those claims? And I'll tell you, I've seen thousands of them, I think, over my years of practice. And you got to look at them and figure out, all right, what defenses do I have? How can I set it aside? And most of the preference claims, the bankruptcy court doesn't really want tried. I mean, they don't want to deal with it. They want to get it resolved and get it off their plate. So what you need to do is look at it, look at the defenses that are available, see how to apply that, and see if you can get it to go away. The defense applies for a contemporaneous exchange. For example, if the transfer was intended by the parties to be a contemporaneous exchange for new value. For example, customer comes in, says, I want to buy, X number of widgets. Here's a check. They take the widgets, they give you a check. That's contemporaneous exchange. There is no credit. There's no antecedent debt at that point. They're paying a check, right? Giving you a check or a credit card payment for the material that they're getting. That would be a defense if it showed up against the preference. So you can say, nope, contemporaneous exchange, not intended to be a on-account transfer, so therefore it would not be a preference claim. So that those invoices for that, any kind of over-the-counter purchase or where they actually wrote a check for it, contemporaneous exchange would not be a preference. So that gives you a little bit of an idea. What about where a customer issues a payment, check, or otherwise for services or goods which are to be delivered to the customer? That would be protected. So they come in and write a check. They say, well, I want this, but you deliver it tomorrow or next week. If they pay for it when they order it, that theoretically is a contemporaneous exchange. So again, you got to look at every circumstance and every transaction to make sure and see how it applies. Because if you just look at the numbers, if you look at the dates and you look at the payments, it might just look like a preference, but it's not. For the ordinary course defense, the transfer must be in a payment of a debt that was incurred in the ordinary course of business of the debtor and the transferee. And it's also made in the ordinary course of the business of the debtor and made according to the ordinary business terms. So the transfer is for a debt incurred, that is, it's on a credit account, and it's in the ordinary course of business. They come in, they buy $30,000 worth of materials. they pay for it in 30, 45 days, if that's the terms, that's an ordinary course. It's just a purchase, a payment, a purchase, a payment. So you look at the definition of the ordinary course, and does it follow within the ordinary course of the transaction with the customer, or is it ordinary course within the industry terms? So that should help you on your defense with that, within the ordinary course. If you don't have an ordinary course, that is, say that your terms are 30 days, but the customer normally pays, say, it ranged anywhere from 25 to 40. If that's the history of the payment of the account over, say, a year period, it seems like you've got a pretty decent ordinary course defense. So again, it depends on the circumstances. If you can put a spreadsheet together to show that, it is awesome. So what about when there's an ordinary course between the parties? That's what you look for. And if you can't do it there, then look for the ordinary course in the industry. So you got to know what that is a little bit. So again, I'm not going to go through all of that on here. We'll have the slides up on our website, and this later you can look at later if you want to. How about enabling loans? Well, this is a defense where it allows protection to the creditor if the creditor makes a loan to the debtor to allow the debtor to acquire assets which serve as security for the loan. For example, you've got a UCC protection on it, or you've got some kind of a claim of lien on it, or some kind of a lien or a claim on the goods that are sold. That could be defined as an enabling loan, or if you're doing a deed of trust against some property, maybe you've got some kind of security agreement that would give you a defense to the preference claim, or at least it should. And another one that's a pretty popular one is new value. And this defense is applicable where the debtor and the creditor have more than one transaction during the 90 days prior to the bankruptcy, and they're netted out. For example, let's say they owe you $50,000. You say, hey guys, I can't sell you anymore until you pay us the $50,000. They go, okay, here's a check for $50. I want to order another $50. Well, that's a new value defense. You gave them new value, and it doesn't have to be dollar for dollar, but it has to be a close. I can't give you any more material until you pay me. Okay, here's the $50,000 that I owe you, but I'm going to now sell you $30,000. That's a new value defense. You're giving new value to the debtor for a return of some payment. So again, that's a new value defense that you could use. Another thing is statutory liens, and this has gone sort of all over the board, and every bankruptcy court looks at it a little bit differently. But most of the time in North Carolina, you can say, well, look, I had statutory liens. I didn't file my lien because I got paid, so I gave that up. So that is a defense to a preference. I got paid. I had lien rights, but I didn't pursue them, so I got paid. That's one of those questions where if you never filed your lien, but if you said, hey, look, if you don't pay me, I'm gonna file liens, and you got paid, I think that helps. If you have lien claims and then got paid, and you canceled your lien rights, that is certainly a defense to a preference. So again, thinking through all that, I think is really helpful to you. We've talked about new value a little bit. So let's talk about what happens if you receive a demand letter for a preference payment. Do you pay it? Do you do nothing? Do you stick the letter in the door? Because you're typically going to get a letter first. Do you respond to the letter? Do you send them a check? What I would tell you to do is don't send the check. Always respond to the letter. And I would say either call us or call whoever you work with attorney-wise to have them respond to the letter, because you want to find out what defenses you have. You want to go ahead and tell them what defenses you have in the letter in hopes that you don't get into a lawsuit. But if sometimes they're barred by time, they don't have a choice, they have to file a lawsuit. This happened to a client of ours recently. We sent a letter with the defenses. They couldn't, I think the trustee had no choice, but because of the statute of limitations, they had to file a lawsuit, so they did. We're now talking settlement because of the defenses, so hopefully it'll get resolved. But take advantage of your defenses. When you receive a demand letter for a preference, certainly respond back to it. Please don't ignore it. and making sure that you plan for a potential preference claim is really big. Is it possible that the funds could be wired to make the payment? Is it possible the debtor's bank made the payment from a loan to the debtor? So again, all these are issues that you need to look at when you're dealing with potential preference claim. What evidence is there that the payment by the debtor or records of the trustee, what records did they review? Sometimes they just look at the check register, or they look at who they did business with 9 days prior to it, and they just assume that any payment that they made was a preference. Not always the case. They cast a huge net, and I understand why they do it, but they cast a very huge net when they're looking for that. So you want to make sure you do that. The question we get sometimes is, well, how long am I on the hook once the customer files for bankruptcy? There's a formula, and I'll be honest, it's on here. I'm not going to go through the formula because, number one, you won't remember it. Number two, if you did remember it, I'd be embarrassed because I don't remember it anymore. It's a fairly long process to look at, but the real simple answer is, generally speaking, general rule of thumb, you got about 2 years from the time period that the customer filed for bankruptcy to have the preference claim come in. So again, you might get notice today of a preference claim or potential, that your customer filed bankruptcy, but it might be up to 2 years from now when you get a letter saying, hey, by the way, that payment you got 2 years ago, that's a preference, we want it back. That's never a fun position to be in. So again, I hope that's helpful to you. If you've got questions, let us know. We'd love for you to submit those to us. You can do it either online on the GoTo control panel or at webinar@vannattorneys.com. And we've got a question here, and it says, suppose you don't have the money to pay for a preference claim, you use the money to pay other people. Absolutely. That's a great question. And I think that's when you go back to, you go, you know what? It may not be a preference claim, and look at what defenses you have. We get that all the time where our customers are, as a creditor, got paid. That money was paid out for whatever reason to others, and you wind up, you say, hey, look, I don't have the money to pay. I've already paid the money out to my vendors, or I paid the money out to subs, or whatever it may be. Hopefully you've got a defense to that. And if not, then I hate to say this because I know we're going to record it and stick it out on our website. Most of the time you can have preference claims narrowed down to near zero, if not zero, but certainly narrowed down from wherever it starts by using the defenses. Now, every case has got to stand on its own. So, I can't tell you that every case you can settle, but I'll tell you I don't think we've had one yet that we couldn't get resolved by negotiating with the trustee or the attorney for the debtor or attorney for the trustee when there is an alleged preference claim. So again, that's a great question. If you have a question, please let us know. You can follow us on Twitter, LinkedIn, look at our blog, or contact me by phone or email, and I'd be glad to help you. The main thing I want to make sure that you understand is when your customer files for bankruptcy, you need to stop sending them notices, stop sending them letters for the payment, stop calling them. All the actions that we take as creditors need to cease, and then start pursuing them in bankruptcy court. That's the real thing that you want to be looking for. So again, if you have any questions, let us know. Hopefully this has been helpful to you today. We appreciate you dialing in and taking part of the webinars, and we'll look forward to seeing you soon. And again, if you have a question, please feel free to contact us later. Hope you all have a great day.